All right, so let's kick it off. So welcome to East State Academy's multiple wills session. We're going to spend about a half an hour covering. We're not obviously going to cover everything about multiple wills, but we're going to cover certainly assets that we can use to shield probate tax using multiple wills. We're going to look at how to advise clients on when to use multiple wills and some drafting issues on that. And this webinar is available to everyone because of Make a Will Month. And so we've opened it up to anyone who wants to participate. Normally this is for East State members, but we're glad to have you aboard, and I'm going to kick in. So we're going to concentrate on the use of multiple wills for the purposes of avoiding probate tax or state administration tax under Ontario's rules. There are other reasons to use multiple wills, such as foreign assets and things like that. But today we're going to concentrate on just trying to avoid having to pay probate tax on certain assets. So the first thing to discuss really is how does it work? And we're probably mostly familiar with that, but we recognize that certain assets do not require probate, a certificate of appointment, in order to transfer them. So for example, I'll give you a simple example. If I have a sofa in my home that I want to give to John, John is not going to require probate to receive that. If I tried to sell the sofa, nobody's going to require probate to sell the sofa because everyone's satisfied that that asset can be transferred without confirmation that the will is valid. So that's just one little example. And so the idea is that you would have a separate will for assets that don't require probate in order to transfer them. The problem with having one will to govern all of your assets is that our rules for probate mean that if you have to probate that will for any asset, then you have to include all assets that the deceased owned beneficially at the time of death. Whether you need probate to deal with those assets or not, you have to pay probate tax on them if they're governed by the will that is being submitted for probate. And so the idea is that you have one will that you submit for probate and you pay probate tax, and that relates only to the assets that require probate. And then the second will is the will that governs assets that don't require probate, and that's the one that you don't submit to the court, and therefore you don't have to pay probate tax on. So let's get into what assets do we not need probate for in order to transfer them. And the classic one are corporate assets, but certain corporate assets. And I want to just draw your attention to, this is the Ontario Business Corporations Act. And this is the authority that allows boards to transfer shares. So if the deceased owned a share in a company, an OBCA company, and died, the question is, how do you get those shares transferred to the estate or the estate trustee? And that's governed by section 67 sub 8, which says that if you don't require probate, then the personal representative is entitled to become the registered owner if they deposit with the corporation the certificate, the share certificate, as well as, quote, reasonable proof of the governing laws, the deceased holder's interest in the security, that is the share, and the right of the legal representative to become the registered holder. So what is that proof? Well, our law is quite clear that the executor gets authority from the will. There's no requirement of probate. Even though certain asset holders might require it, it's not required by law. And so if the board is satisfied with the will, even if it's not probated, then they'll transfer the shares. So why can't we just use that in every case? Well, and why do we limit it to private companies? Well, because you need the board's approval to accept the will, which is not probated, in order to deal with that share and transfer it to the personal representatives. So one of the important things is who controls the board. Obviously, if the deceased person was the sole shareholder, they controlled the board, and when they die, the shareholder controls the board, their personal representative, and therefore they will accept, no doubt, being the personal representative and the director, proof that accept the will without probate and allow the shares to be transferred. So that's why we can get around probate when the board is okay with accepting a non-probated will. And you're looking at section 67(8) of the OBCA for that authority. If you don't control the board and the board says, you know what, I'm not accepting the proof that's required, this will that's not probated, that's not for me sufficient for me to transfer the share certificate from the deceased to the personal representative, then you're stuck. Then you might need to get probate because this prior section says probate is enough to transfer it. So that's why when we talk about what assets can we deal with in a secondary will, the first kind of assets are shares in a private corporation where the deceased is the sole shareholder. Okay, that's the first one. The second one is shares in a private corporation where if the deceased is not the sole shareholder, they control the board. Okay, or the directors are going to be friendly. If the directors are going to be friendly and accept a non-probated will in order to transfer the shares, then you're going to be good to go. The other thing is shareholder loans. Loans owed by the corporation to the shareholder, those don't typically require probate. Again, if you've got a friendly board. That's really the issue. Who controls the board? Because you can imagine if I'm an independent person and you come to me with the shares and you give me this will, I may not be satisfied with that. I may say, you know what, I want a probated will because I want that comfort, just like a bank would require probate. So that's really the key aspects. So not every private corporation the shares in any private corporation can be transferred without probate. It's going to depend on the control of the board. We'll get to more about that in a second. So that's one big group of asset, and often that's the most valuable asset, and that's the asset that's going to avoid the most probate tax by using a separate will. Then we come across a bunch of other assets these are what I call the classic assets that we figure don't need probate. And these are assets that we would typically say, let's use a separate will to deal with. So the one I gave off the top, the example was personal effects. So nobody's going to probably require any probate to sell a sofa or to transfer your artwork to the beneficiaries or your personal effects, or jewelry. So that's why that typically doesn't require probate. And so that's why we would stick that in the non-probated will. The other big asset that is now much more important than it was even 10 years ago are assets that are held on a resulting trust. We see this very commonly where the deceased owns something jointly with one of the kids. And the intention is that the deceased is the true beneficial owner of that asset. And therefore, it's to pass, even though it's going to pass automatically by right of survivorship to the surviving joint tenant, really the real beneficial ownership is held by the estate. And that gets us into core issues, et cetera. But let's assume it's being held on resulting trust for the estate. With one will, you still have to include the value of that asset for probate. But you'd say, well, passed automatically, except that the beneficial ownership was the deceased. So once you have to probate that will for any reason, if it governs these assets that are held on resulting trust, then it's going to require probate, and you're going to pay probate tax on that. Similarly for bear trust, assets that are held in a bear trust. So if you've got that sort of planning, then what you really do need is a separate will. Use that secondary will or the non-probate will to deal with assets that are held beneficially by the deceased, but where legal title might be held by somebody else, and therefore you don't need probate to actually transfer them, but you still want to deal with them under the will. The third one on that list are registry system real estate. So that's any real estate in Ontario that's governed by the registry system, including properties that have been transferred from the registry system to the land title system while the deceased was on title, the so-called first dealing exception. So if the transmission application after death from the deceased name into the estate trustee's name would be a first dealing with the land since it was converted from the old registry system to the land title system, then that's another asset that doesn't need probate. And so you'd want to cover that in the non-probate will. The fourth one are debts owing to the deceased. So let's say my kids owe me money and I'm going to forgive those debts. If that's the case, then if I only had one will, I'd have to pay probate tax on the value of those debts, even though they're being forgiven. But since I'm never going to collect them anyway, I don't really have to worry about enforcing the debts. And so I would put those in the non-probate will because I don't need probate to forgive them, in essence. And we'll talk about sort of encumbrances. That's slightly different. But so if I've got debts that I'm going to forgive in the will, then those are certainly assets that I want to put in my non-probate will. Now, I'd like each of you, or as many of you who are interested, to think about other assets that you see not needing probate. And if you want to send me a chat, just put the name of the asset that you're thinking of, and I'll add them to our list. But here are some additional ones that are less common, but still something that you could probably avoid probate on. So if you have life insurance that the deceased is the owner of life insurance on someone else's life, that might be an asset that doesn't need probate and therefore could be governed by the secondary will. Partnership interests typically don't need, especially if it's a small partnership, won't need probate to transfer. And so that's another asset. Loans from any family trusts that typically you're not going to need probate to collect those loans. So money owing to the deceased from a trust, you'd rather not pay probate tax on those. So I would put those in the secondary will because I don't think they require probate, especially if the trustee of the trust is friendly, right? That's the key here, that they're going to accept just an unprobated will. Shares in foreign corporations. So there's a risk here that under the foreign jurisdictions law, that the transfer of shares might require probate. So there's that risk, but that's something to look at. And what I would typically do is ask a lawyer in that jurisdiction, how do shares get transferred from a deceased name to the personal representative? Is probate required? Is not probate required? Because it's a foreign corporation, it's still governed by Ontario law for the purposes of probate tax. And safety deposit box contents, powers of appointment. If I have a power of appointment and I can direct who the beneficiaries are, that might be something that could be dealt with without probate. And digital assets. Did anybody have any other assets that they think we should put on that list for people to think about that might not require probate? I'm not seeing any chats, but if anybody has, you can throw them in the chat and we can return to that if we come up with any additional assets. So again, we're thinking of assets that we've come across that we've been able to deal with without probate. So that's something to point out. So let's talk now about considerations. When are we going to talk about or guide our clients to seriously consider using multiple wills to avoid probate tax? So, depending on the client's age and health, that might be a factor. If a client is young and there's no concern about an early death, and the client might be less willing to spend money now for their estate to save money when they die, if that's going to be in 70 years, versus a client who's in their 90s or unwell, probably that spending that money now to do multiple wills versus single wills might be worth it. the current asset values. So let me just give you an example of how I demonstrate that. So here's an example of clients who have, a bunch of assets, private company shares, and assets that are held by a bare trust, and personal effects and things like that. And so I'm going to be able to demonstrate to the client, what, based on the value of your assets, what are we going to save by using multiple wills? And so I can demonstrate that if you see, I just click on this button and demonstrate to the client that if we use multiple wills, you're going to save $94,000 based on this snapshot, today's date kind of thing. But I can demonstrate to the client just by clicking a button that, here's the tax savings. And again, it's not today, it's down the road, and it's based on current values, blah, 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 and et cetera. But this can very easily demonstrate. So what's it doing here? Well, it's looking at what assets, it's deducting probate tax on private company shares, shareholder loans, personal effects, assets that are held in trust, those kinds of assets. And that's why it's demonstrating that. So that kind of thing, if you don't use eState, then you're going to sort of do that in your head. And it's a pretty easy calculation of $15,000 per million. What's the future growth probability? So, what are the chances that these assets are going to go up in value, or there's going to be other assets that are going to be assets that you can avoid probate on? That's another thing, right? So I would say to my client, oh, well, your company's worth, 100 grand. The tax saving on that is $1,500. Do you really want to do that? Well, then you ask them, oh, tell me what's going to happen. Well, we expect it to go in the future. I said, are you going to get any life insurance? Yeah, I'm going to get life insurance. Well, one of the things that your insurance agent might say is have the corporation own that. Well, all of a sudden, if that's the case, it's $1 million policy. The corporation, which had $100,000 worth of value, now has a $1.1 million value on death. So that's an example of future growth probability coming into it. Pre-death disposition, you look at it, you do a title search, you say, oh, I found that this property doesn't need probate to transfer because it would be a first dealing when you die. That's all great and fine, except that then you ask the client, are you keeping this property? And they say, no, I'm going to sell it. Well, then if that's the only reason you're doing tax saving, then that's a consideration. You might not want to do it. Resulting trust planning. So first of all, obviously we do want to canvass our clients about, are they, do they hold things jointly with other family members, and what's the purpose of that and all of that. So if you find that the client has some sort of resulting trust planning, then that's certainly an indication that you should be using a multiple will strategy. If they're not, then what they've probably done is gotten advice from their financial advisor that says, oh, make your kid join on this bank account. It's great. It's going to save probate tax. Of course, it doesn't save probate tax if you only have one will and you have to probate that will for any other reason, because it's beneficially owned by the deceased. So that's an indication. For older clients, especially single older clients, I would often recommend doing this, a separate will, secondary will, because of the possibility that down the road they may transfer their home and make a joint with one kid to save probate tax, sort of last minute planning. If you haven't done the secondary will, then that planning might not work because you've got only one will. And you're going to have to include those assets that are held on resulting trust for the estate in that if you probate that one will. So this is one where it might not be indicated right if you just look purely at the assets, but look at the circumstances. Look at, are they older? Are they single? They've got kids, those kinds of things. There's possibility of multiple will planning opportunities there for resulting trusts. Another thing is, how simple does the client want things? I mean, it does make it a little more complicated. You have to explain to them, oh, I've got, you've got two wills, and this will is going to govern this, and this will is going to govern that. And, oh, it's very confusing. I can't remember why. So that's another thing. And fees, right? Because you're going to charge more to do a multiple will than you're going to charge for a single will, in my experience, at least I would. And the idea of future flexibility, that sort of ties into maybe they're going to have a corporation down the road. Maybe they're going to use a resulting trust planning. Maybe they'll have trust loans. Maybe they're lending money to their kids that they're going to forgive. All of those things. Obviously, you have multiple wills. It has some benefit. So somebody asked, what about trailers, cars? For sure, those can be, you could typically avoid probate tax on those. And often cars are dealt with under the definition of personal effects. So let's turn to drafting issues. So just want to do some. So I'm going to just generate multiple wills instead of single wills here using eState, and then I'm going to take you through that. So just give me a second here. So we're going to talk about, there's a bunch of drafting issues. So if you're doing this manually, okay, I want to raise some issues that you should check your own precedents for, because there are issues that can get us in trouble when we're drafting multiple wills. So here's our multiple will. So let me just click on this and open it up. And so what I'm going to do here, let me just go here for a second and go to drafting issues. So the first thing is, how are we going to define what assets are in which will? Okay, so there's a few ways of doing it. One is, I'll go to the first one, which is a basket clause. For those of you who are aware of the Milne case, this got us in trouble, at least at the trial level. But a basket clause is a clause that just says, look, any asset that doesn't need probate is governed by my non-probate will, and any asset that does need probate is governed by my probate will. That's a basket clause. That, I think it works, certainly after Milne. So that's one option. The second option is using specifically named assets. And I'll just give you an example of what I mean by that. So in eState's precedent, we sort of use a hybrid of the different options. So one is where I define the typical assets. So personal effects, digital assets, corporate assets, and this would mean the shares as well as shareholder loans, trust assets, those are the resulting trust assets, registry system real estate, that's a first dealings exempted real estate, loans owing from a trust, other life insurance, partnership interest, these are loans from children that I'm going to forgive. So that's another way of doing it, and more common, I would say, is the specifically named assets. So then there's the other, so you could use specifically named assets, you could use specifically named assets and a basket clause, and you could use a disclaimer clause. And that's how our precedent works. So it means, it means all of these assets that go in the secondary will that I think don't need probate, but it does allow the executor of the secondary will to say, here's an asset that falls into the definition of, for example, partnership interest, but for whatever reason, I need to probate it. Now, I got a problem. I need to put that back into the primary will and pay probate tax on it because I need probate for it anyway. So that's what this idea of a disclaimer is. It allows the secondary will executors to take an asset that would have fallen into the secondary estate and put it into the primary estate. So that's how we deal with that. And I'm just going to show you that disclaimer clause because it's in the secondary will, naturally, because it's the disclaimer is here. So this allows the trustee to disclaim any assets if my and I would suggest to you that the disclaimer clause have a specific test. And this is what we got out of Milne. Milne suggests that you need a specific test for when they can disclaim it, and when one asset falls into one estate and an asset doesn't fall into the other. And this is if the trustee determines that a grant of authority probate is required. So that's the way we did it. And we took that sort of from the Milne case. So that's how we use disclaimer. And you'd use similar language if you're using a basket clause. So that's the first. So that gets into the whole idea of definitions. And so what we do is we define all of those, and the definitions are the same in both the primary will and the secondary will, or what some people call the probate will and the non-probate will. Legacies and annual sums. Annual sums are specific amounts that are paid every year to a beneficiary. Legacies are specific amounts, right, paid to a beneficiary. Those can get you in trouble with a secondary will as well. And so I'll just show you some drafting tips on that. So what we typically do is let's go to an example of a legacy. So here's an initial gift, a legacy of $150,000 to the World Fund in the primary will. That's what we typically do is put in the primary will. But let's say there are no assets in the primary will. Everything's owned, all your assets are corporately owned or held on a resulting trust. Then this legacy would lapse. There's no money to pay it unless we incorporate it into the secondary will. And so that's what we do automatically. And you should make sure that you do that in yours. That says that, to the extent that the gift paid to be paid under the primary will is not paid. And I say it's not paid as a result of abatement. I don't want any argument that it's not paid because someone lapsed. It lapsed because the beneficiary predeceased or something like that. It's not paid because of abatement, i.e. there's not enough money to pay it, then pay it out of the secondary estate. So that's what we have built in. And that's automatic for anytime there's a legacy, this clause would get generated. The same thing for annual sums. For those of you who occasionally draft a gift by, for example, let me just show you, here we're saying at 25, you'll get $25,000 a year every year starting at a certain age. Well, the problem with that is we might put that in both wills because we don't know which estate it's going to get paid out of, but we want it to be a total aggregate amount. And so we put in automatically, if you use an annual sum with multiple wills, you should have this clause that says, look, it's a total amount regardless of which estate it's paid out of. So we have that. And that's really anytime you're doing non-percentage calculation. So if you ever draft something that says, and I don't have an example of this, but it would generate, if I put in a gift that so-and-so gets the greater of, 5% and $100,000, I'm going to have the same problem with that because what's 5% of what? And so I'm going to make sure that I calculate that in my definition. And eState would do this automatically. It would say, okay, when I talk about an amount, which is a maximum, here's how I want you to calculate it. Take the percentage as a percentage of both the primary and the secondary estate. So those are examples that can get you in trouble. And I'm just going to deal with the last one is hodgepodge. There's another example. Let me just call it up, where you can get in trouble. So in this case, I'm going to just go to the secondary will. And in this case, I created a hodgepodge clause because I said, so this was a divider, 50% to one person, 50% to another person, but it was to take into account a hodgepodge for one of the people. So the gift is subject to the hodgepodge provision. And so I'm saying, okay, Blake Smith owes $100,000 to be taken into account, but only to the extent that that adjustment hadn't been made under the primary will, because otherwise there'd be that adjustment under both wills. So these are little technical things that if you don't remember them, and the good thing about, and I'll plug eState for a second, the good thing is you don't have to remember it for eState. eState remembers for you. If you do a hodgepodge clause in a multiple wills, you're going to have this issue. The final point I want to make is this issue about asset gifts. So let's say, you're making an asset gift. Let's say it's clearly a condo, okay, a condo. You're giving a condo away to someone. And you'd say, well, of course it's going to be in the primary will because to transfer a condo always needs probate, right? If it's in the deceased's name. And so I'm just going to put it in the primary will. That's what I'm going to do. And then it turns out what happens is down the road, somebody tells the spouse, oh, by the way, you should make a joint with the kid and hold it on a resulting trust or bare trust. Now, all of a sudden, that asset that clearly required probate if nothing was done with it, doesn't require probate and should be in the secondary will. So the way that we do this is we put every asset gift in both wills. And what we say is, to the extent that it forms part of my primary will, it's governed by my primary will. To the extent that it forms part of my secondary estate, it's governed by my secondary estate. You don't, in my recommendation is don't try to guess which will that's going to end up in, because it's quite possible it could end up in the other will. Either because, let's say you've got a home that's a registry system real estate. So you're like, well, for sure that's going to be in the secondary will. Of course, it applies to substitute property. And so they sell it and buy a condo. Now that condo is in the primary will. So very important, I think, to put those kinds of gifts in both, but carve them out depending on whether they're in, one will or the other. So it is now 1 o'clock. I went a minute over. So I wanted to, that's what basically our time is up on that. But I want to thank you. And if you want to stick around, please do, because there are questions in our chat, and I'm going to deal with them. If anyone has other questions, you can put them in the chat and we'll go through them. I hope you found this useful, and I'm glad to have you aboard. And the software, this is just, Ashley, you're asking, it's called eState Planner. And if anybody's interested, we developed it. I'm one of the creators of it. And I use it to generate all my wills. And you can generate a multiple will in the same 10 seconds that it would take you to generate a single will. So the slides will be available. Certainly, and if anybody is interested in looking at eState for planning and drafting, feel free to reach out to us, and we'd be happy to show you a demo and how it's used. And so for sure. Now let me go through some of the questions. So if client adds an executor to a bank account as joint tenant with the understanding that it's to be distributed to the beneficiaries, and the probate needs to be probated, the only way to avoid probate in the bank account is to have a secondary will. That is correct. That is correct. And the same applies to jointly held real estate. Yes. If it's held on a resulting trust, so in other words, the asset really belongs to the deceased, then the only way to avoid probate tax on those is to have a secondary will. That assumes if you don't need to probate any will, then you're going to say probate tax, obviously. It's if you have to probate a single will for any reason, then you've got to include everything, if that's the only will you have. I hope that's clear. Employers' shares in the US, would they need probate? Well, that's one where I would ask for advice. You could always put them in the secondary will with a disclaimer clause that says, look, if it should be in the primary will, well, we'll disclaim it. So that's an option there. Hope I got that. With eState Planner, is there a fee for use different from using? No, the same cost. There's no additional cost for secondary multiple wills or single wills. It's a one-time fee whether you generate a will. You could start with a primary will and then do a multiple will. It's a one-time fee per client. So you don't get paid. You don't have to pay per document that you generate. So what I've had to happen in my own experience is a client says, let's go with multiple wills, and then they switch. No, let's just go with single wills, or vice versa. And of course, you don't have to do anything different. You just click the button and generate the different will, and it has all of it in there. So it saves a lot of time for me. Anyway, it includes powers of attorney. If you generate any document, you're paid. It's a one-time fee, and then you can generate everything else. Yeah, and if anyone's interested about eState, feel free to reach out. I don't want to bore people with it, but stay on after and be happy to show it to you. If house is joint but no resulting trust, then no probate. Correct. But what you're going to want to do, so what I'll demonstrate something here. So let's say you take the home, okay, and you make Rachel Jones the joint owner. Okay. So that's going to save the probate tax on that asset if it's joint. Okay. So that being said, what you're going to want to do is document that. And so what eState's going to do, sorry, let me just do one thing here with James. So let's take the house, for example. Do I have a house in here? I got a cottage. I got a country house. Let me just do one thing here. Let's add a house. Okay. So this person has a home, and it's worth, it's Ontario, let's assume. So for probate taxes, you got $15,000 worth of probate tax that you're trying to save. Okay. And we're planning in the descendants only scenario, and we're going to give it to, let's find the home here. We're going to give it to Rachel. And you can see we've saved $15,000 of tax. However, Rachel we're going to get we should get a warning in a second that says, oops, I don't know why that is. that's going to tell us we're going to have to demonstrate that and confirm that this person is to receive this not on a resulting trust, but on as a true gift. And so you're going to want to document that in that situation, Bill. Okay. Because again, if it's a child, there's this presumption. I don't know, maybe I don't know who the people are, so that's maybe why it's not warning me. But it's going to depend on who the person is, right? There's a presumption if it's a child that it is on a resulting trust. If it's somebody else, there isn't that presumption. So in my hodgepodge clause, yeah. So you can choose, by the way, if I know we had a hodgepodge clause, descendants only. I don't know where I did that. Maybe it was in this one. Nope. I don't know. So yeah, when you do a hodgepodge clause, let me give you an example. If you do a hodgepodge clause right here, you can leave current amount empty and it'll just say, okay, but you'll want to include future amounts. That's the idea. So it'll say any amount that's owing from me, including future amounts. So with a spouse, let's say you wanted to confirm it as a gift for a spouse. So what I would recommend, if you made a joint asset with a spouse, then when you generate the will, and eState would warn you about this, when you generate the will, you want to use the joint designated asset confirmation, because you don't want anybody saying, well, that's not a true gift. And so I would recommend that, especially if there's other residuary beneficiaries. If they're not other residuary beneficiaries, you don't have to worry too much, because even if it was held on a resulting trust, it would go to them through the will. But often, as a matter of course, I would include that. And I think I've got an example of that here. Yes, right here. So it just confirms. So let's just see if anybody has any other questions. Yeah, so all the advice that eState gives is contextual. So it looks at who's the joint asset holder, who the residuary beneficiaries, and then warns you based on those issues. So it's not just one, we're going to give you a warning every time something's joint. No, it's going to look at, oh, okay, we have a joint owner and they're different from the residuary beneficiaries. Now we need some kind of confirmation. The breakdown. Yes. So what we're going to do here is we're going to do 20 minutes substantive and 10 minutes professionalism. Let's do 15-15, actually. Let's do 15-15. I think that's accurate. So thank you all, and hope to see you next week.